Afternoon, everybody. Thank you for joining today's webinar. Apologies in advance for any coughing that you might hear in the background. That's me, usual pre-Christmas illness. So the webinar today, we're going to be talking about the GDPR and the impact of the GDPR on the education sector and how you can start preparing yourself, your organisation and your staff. Webinar is going to be run by myself, Nick Richards. I'm CEO of Me Learning, and my colleague Piers Clayden, who is the practice partner for our partners, Clayden Law. In this afternoon session, I'm going to shortly pass over to Piers, who's going to talk about a little bit about the background on GDPR, why it's a game changer, and more relevantly to everybody on this webinar, the key implications for the education sector. And then I'm going to talk a little bit after that about how we've created some online content that can help your schools, colleges and so forth prepare for GDPR, and then give you a brief demonstration of the e-learning content. And then I'll quickly hand you over to my colleague Kevin, who's sitting in on this presentation. Who'll just briefly introduce himself to you and provide you with his contact details should you have any more questions for either ourselves or for Clayden Law. We've got quite a large number of people on the call today. There is an option for you to ask questions, and please do enter questions. We will deal with questions at the end, and apologies if we don't answer your question. It's purely just because we may not have time, or it may well have already been answered through the presentation. But any questions that we weren't able to address, we will pick up after the event and email those out to you. And the webinar is also being recorded and will be available to all attendees, and we'll provide those details at the end. So without much further ado, could I introduce my colleague Piers and hand over to you, sir?
Nick, thanks very much indeed for that introduction, and good afternoon everyone. Thank you for joining the webinar on GDPR and its impact on the education sector. Really pleased to be with you today. So just a little bit about the background, where it's come from, and you know, the sort of immediate impact on the education sector. It is a piece of EU-derived legislation. It has been sort of published now since February 2016, so we have had fair warning of this coming down the line. Brexit won't make any difference at all to the coming into force of this reg, because for a whole heap of reasons, not least of which the UK government decided that they're going to put their full weight behind making sure it's incorporated into UK law, whether we are within or without the EU. So, and I think obviously there's a political decision behind that, just to make sure we're aligned from a data protection point of view to help with continued trade going forward. And it impacts across all organisations throughout the land, big and small, but obviously particularly significant for schools and the education sector, because the personal data which they hold is obviously key to their function. It's what they need. It is what they do. They hold records about pupils, staff, parents, alumni, and therefore personal data and data protection is obviously key to their compliance picture and their risk picture. That risk picture, I'm afraid, is increasing exponentially with GDPR coming online. Not only the fines, which have had quite a lot of widespread publicity, but also the fact that individuals now will have a greater ability to bring an action for damages, to sue organisations who don't look after their personal data correctly, or use it for purposes which they didn't have legal grounds to do so. There's a bigger risk picture here, and that's why it's really important to make sure that your kind of leadership level personnel within the school, within the learning institution, are fully on board with this issue. As public bodies, and I'm assuming for these purposes that all of, all or at least the vast majority of the attendees on this call are public bodies on the basis that they are state sector schools. They will have a higher compliance threshold under GDPR for various reasons, and the public body is defined now through the new Data Protection Act, which again is now going through Parliament, which fills in some of the gaps that GDPR allows local states and member states to legislate for. One of those areas where the UK have done that is just to put some definition around what a public body is, and that is anyone to whom the Freedom of Information Act applies. Now, of course, the GDPR is concerned with personal data and special and sensitive data, which is now called special categories of data of everybody, young or old, but they do classify children as being vulnerable and deserving of special attention. So that risk profile clearly increases when you're looking at a school scenario. I've mentioned the fact that data subjects will have the right to sue organisations for compensation. The good news in some respects is that this is an evolution, not a revolution. So many of the concepts and principles that you should be familiar with under the current data protection regime remain, and many of the exemptions and qualifications and little nuances that currently exist under the DPA, particularly in the public sector for data processing, are going to be carried over into GDPR through the UK's data protection bill. But nevertheless, there are some additional elements that the GDPR introduces, and these will call for, I'm afraid, quite an intense expenditure of resource and time and money in order to meet your compliance burdens, or at least try to meet those compliance burdens. And IT and technology will be key to this, and for many organisations it tends to fall to the IT department to kind of drive this forward. But actually, it really isn't just down to them. The GDPR is not just an information security issue; it goes a lot wider than that. And so it really needs the entire staff of a school to really pitch in and help drive the compliance forward. And Nick, if we could go on to the next slide, please. Just one back, I think. Thanks. So one of the biggest areas that the GDPR has, which is new actually under the GDPR, is this so-called new principle of accountability. And the sort of short way of describing this is it's not just complying with the law and ticking the boxes, it is actually being seen to comply. So in other words, being able to demonstrate compliance suddenly becomes really, really important, and is a continuing thread throughout the entire GDPR itself. And so, what areas practically does this touch upon? Well, schools are going to be required to carry out a data mapping exercise in order to work out exactly what their personal data landscape looks like from a sort of top to tail, cradle to grave scenario. So it's the who, what, where, how, and why of personal data. Whose personal data do you have? Why do you have it? What uses do you put to it? Where is it stored? And you can't really move forward with getting your compliance house in order without knowing exactly what personal data you're dealing with and why. One of the other requirements on the GDPR is that public bodies must have a data protection officer, and as a public body, obviously this impacts on schools. And I've been doing a little bit of research just this morning to see what the education sector is doing in this area, and I was anticipating hopefully that your sort of local education authorities might be helping schools with this by effectively having a shared resource, and I couldn't actually find any evidence to that effect. So the obligation to have a DPO is quite an onerous one actually, and whilst you can share a resource, the fact is that it's basically what, it is one DPO. A DPO has to be part of the school compliance picture. It doesn't have to be full-time, so therefore that sharing is an option, but nevertheless it is a requirement, and that person has to be properly experienced and qualified. It doesn't have to be a lawyer, certainly it doesn't have to be a technician, but it has to be someone who knows their way around the compliance landscape. And indeed, it has to be someone who is not going to have a conflict of interest with the school. So again, I was just looking at this morning, the commentary seems to suggest that having a teacher being a DPO might be problematic because there may conceivably be conflicts of interest in that scenario. So that's certainly a hurdle that schools are going to have to come across. The GDPR is quite spans a little bit more than the DPA on information security measures, and this is obviously one of the key areas on the GDPR, making sure that personal data is kept secure, and organisations have the right measures in place to look after that. And so, as part of your accountability, you have to show that you can do this. And we are increasingly aware now that certainly public sector IT systems are out of date, not being renewed, patches aren't being applied, and we only had to look at the NHS case earlier this year or last year, which caused widespread havoc, and that was due to upgrades and patches not being applied as and when they should have been done because of, I'm assuming, limited resources. So that's the sort of area under the world of GDPR which would really lay a school open to pretty harsh scrutiny from the regulator, the Information Commissioner's Office. The GDPR pushes quite strongly privacy by design, i.e. making sure that privacy is at the heart of how organisations look after personal data. So you only collect what you need, you don't keep it for longer than you need to keep it, to the extent you possibly can, you anonymise data so that not everyone, or you have access controls so that not all members of staff have to have access to all data, all personal data. You use pseudonymisation, which is not that easy to say and probably even more difficult to put in place. But the point there being that you can have it is a risk mitigation measure to make sure that it is an extra layer of security around personal data. And encryption is singled out for special mention on the GDPR as an excellent way of mitigating your data protection risk. So, in terms of what to do practically for schools, you need to know where you are now. You need to know where you are now in order to see where you need to get to for GDPR compliance. So, doing an audit is a good starting point. Making sure you get these records up and running, and make sure your DPO is appointed in good time, so that person has plenty of time to get themselves up to speed with your own particular organisation, because they have to be embedded in that organisation but independent from it. Make sure your policies are kept up to date and updated, particularly when dealing with children. Those policies have to be written in a way which you look at the audience for the policy, and if the audience for that policy is children, then obviously they have to be written in a way that children can understand. And staff training is a big key to demonstrating compliance with GDPR, and this is where the me-learning product and modules is a great way of achieving this, and Nick's going to amplify that later on in the course. But the great thing about these online e-learning modules is that it's an instantly verifiable and auditable way of showing that you are taking privacy seriously, and I really commend them to you on that basis. Consider whether you are able to sign up to any industry-specific codes of conduct or certification measures that there may be out there. I'm not aware of any yet for schools, but nevertheless, there may well be some, but obviously there are sort of British standards and ISOs that are there. And the ISO Information Security Standard 27000 is a great way of getting you some way towards GDPR compliance. I can't say it's the whole picture because GDPR is wider than that, but certainly it is a very good starting point. And those of you who are using good information governance practice now will find getting to a GDPR compliance situation a lot easier than anyone who isn't. Nick, perhaps we move on now. Thank you. So one of the in terms of changes, this isn't a change as such, but I want to draw out some specific points which I think are important for schools. In order to process personal data lawfully, a school needs to have legal grounds to do that. And if you don't have a legal ground to do it, you shouldn't be doing it. That's the first point. Now, I mentioned public authorities having a higher compliance burden. Legitimate interest, which is the ground currently under the Data Protection Act, which allows organisations to process personal data where they are able to argue that they have an interest, a legitimate interest, and the processing is necessary for the attainment of for pursuing that interest, and that processing does not outweigh the rights and freedom of individuals. They are able to carry out processing for that purpose. Now, the difficulty for schools as a public body is that legitimate interest is not available to you for your core activities. Certainly, it may be available. And again, we are waiting further guidance on this. It may be available for non-core activities, and for example, fundraising might count as that. So, using fundraising and processing personal data, it may be possible to argue that you have a legitimate interest to do that if you haven't got consent. But broadly, your public functions and consent are likely to be the sort of go-to grounds for many schools. Under the GDPR, the consent hurdle has got higher, so the GDPR is quite prescriptive on what makes up a valid consent. It has to be freely given. So, and this is an area where public bodies find this is difficult to comply with, because, of course, as a public body, the balance of power is very much in the authorities' favour rather than the individuals. So, how freely given is that consent? It has to be very specific to the processing activity that is being carried out. It has to be informed, and it has to be unambiguous. So, in terms of the sort of compliance, getting ready for compliance, thinking about the sort of processing you do, and thinking about for each of those processing, what is your legal ground for doing it, and then that in turn has to be reflected in your external-facing information notice. This is the what is often called a privacy policy or a privacy notice. It's called in the DPA a fair processing notice, and the requirements for that have been amplified now. So your information notice is now, the requirements of the information that has to go in there is now a lot longer than it currently is. Ironically, the GDPR requires the information notice to be concise and intelligible, but at the same time, that the requirements they put on organisations for those notices have gone through the roof. So there's a certain irony there, which we all have to grapple with. And where you have historic consents, to the extent that they do not meet the GDPR standard of consent, then, and to the extent that you are still looking to rely on those consents, you would need to go out and get those consents, and repay for those consents. I've heard it described as. Okay, Nick, thank you. Thanks. The next picture is around how organisations and schools conduct their activities, and I know for schools particularly, outsourcing is a major part of how they conduct themselves operationally. The picture under GDPR has become more complicated, and the risks of using external organisations to carry out activities to process personal data have increased. So, for example, I know schools management systems like I believe it's called Capita, Sims is an example of an outsourced function there. Perhaps shredding of records or cloud storage of personal data. All of those are examples of data processing. And whilst data processes, I beg your pardon, are now directly falling under the GDPR, so they will be directly liable for breaches of certain elements of the GDPR. By the way, that is not the case at the moment. Data processors have no statutory exposure for failing to breach, for failing to meet the data protection requirements. But under GDPR they will, but nevertheless, even though they have their own risks, the primary risk for using data processors and the primary responsibility for getting it right is very much on the school as the controller. And it is incumbent on the school to make sure that they have really done the due diligence and they have the records to show that they've done the due diligence to make sure that those organisations have given sufficient guarantees that they will be able to comply with all aspects of the GDPR. Not just the ones that apply only to data processors, but the ones that apply to their data controller as well. And there are certain provisions in the GDPR which the GDPR requires to go into the written contract between the school and the external organisation. Certain requirements about staff, confidentiality, no further subcontracting without consent, and generally assisting the school with its own compliance requirements and audits. So in terms of where to next for schools, really important to make sure that your key data processing agreements with key suppliers are compliant with GDPR. And to the extent that you have agreements with big organisations, it's important to go out to them and ask them what are they doing about GDPR compliance. To the extent that you are using procurement terms, perhaps mandated or voluntarily from your local education authority, make sure that those procurement terms are GDPR compliant. And in there, make sure, when you do appoint a supplier, make sure you've got records of the checks that you've made on that supplier and the decision-making tree you've gone through before they've been appointed. Make sure the agreement really clearly and exhaustively sets out the processing that they're going to do, and to the extent possible, make sure that the risk of that processing and the risk of getting it wrong sits fairly on their shoulders and not yours, so that you might do that by way of an indemnity. Okay, next, thank you. Next one. So breach notification, this is a new introduction under the GDPR. At the moment, there is no requirement for organisations to be forced to inform the regulator in the event of a security breach. That changes under GDPR because organisations that suffer a security breach, and that's an accidental, unlawful destruction, loss, disclosure of, or access to personal data. So it's wider than just a hack. It could be anything from sending out an Excel spreadsheet mistakenly to a wrong recipient with numerous details on it, that sort of thing. That would be a security breach. There is now a requirement to inform the regulator within 72 hours of becoming aware of that breach. Unless there is no risk to individuals, and whether there is a risk or not, obviously will very much depend upon the circumstances. But there is also a requirement to tell the affected individuals as well without delay if they're like to be a high risk to their rights and freedoms. So particularly in a school scenario, you know, children's email addresses and such like, and you know, parental email addresses. Which might be used for verification purposes. You know, those are quite risky areas, and so you would be required, I think, to take very seriously your obligations to inform individuals in the event of a security breach. You have to have a breach register in place, so to keep a record of any breaches that might happen, and a reporting system for any any breaches as and when they occur. So where schools can seek to mitigate their exposure here, for example, encryption is a great, I mentioned this earlier, the ability to be able to say, actually, yes, that laptop has been left on the train, but actually it's got a industrial strength password on it, and you know, state-of-the-art encryption, which allows it, which means it's unintelligible, is a great way of mitigating any potential risk to individuals. So whilst it might not get past your obligation to inform the regulator, it may nevertheless save you from having to inform individuals. And this is an area that attracts the slightly lower level of fines. It's the 10 million euro, 2% turnover fine. And of course, if that security breach reveals any other underlying data protection breaches, the organisation would be liable for those fines as well. And where the breach happens by a data processor, their obligation is to tell you as the controller, but not the regulator. So in terms of, Nick, if we just go on to the next slide now, please, in terms of practical points, the really good idea, first of all, to get a sort of incident response plan up and running and to make sure it works. So in other words, you know, put it to the test and trial it. Look again at your information security measures. Can breaches be detected and managed and quickly? Are your data protection records fit for purpose? So could you quickly work out whose details have been the subject of the security breach, and think seriously about encrypting certainly information which is of a sensitive or a high risk nature. Thanks, Nick. Next one. And I just want to finally touch on the question of data sharing, which I know is a big part of the sort of data protection, personal data picture for schools. And this is really, I'm talking here about where you as a controller, a school as a controller, is having to share information with other organisations, but they are not doing it on your behalf, so they are another controller. So, for example, sharing a parent list with a PTA, Parent-Teacher Association, as a separate body, that might be seen as data sharing, or sharing with examining boards or local authority or the police or medical staff, that sort of thing. There's a really good data sharing code of conduct on the ICO website. That at the moment, the last time I looked, and that was very recently, hasn't actually been updated for GDPR. I think actually a lot of it will still will still be relevant and pertinent, but I just wanted to draw out a couple of sort of GDPR specific things there which are worth thinking about. So the data sharing itself, so, you know, you're passing personal data from yourself to an independent body who is not working on your behalf. Think about, do you have the legal grounds under the GDPR to do that, because that's a processing activity. It's potentially a risky activity, so think about whether actually you need to do it. Is there another way around? Is there another way around it without sharing that personal data? Have you thought about the risks of doing it? And I skated over slightly earlier the whole privacy by design element, but one of the things the GDPR does recommend, not necessarily mandate, but recommend, certainly for high risk processing, is doing what's called a privacy impact assessment before the activity takes place. So this is a process by which you look at the activity, you think about the risks, the personal data risks from doing what you're doing, and you think about risk mitigation, ways in which you might be able to mitigate those risks before you do it. And if you've got that documented, again, that is a great way of showing any regulator who might be auditing you that you are taking your privacy responsibilities seriously, and certainly will stand you in much better stead if you can say, yeah, I had thought about this and this is what we did. Yeah, unfortunately something went wrong, but we had done our best to try to mitigate that problem. That will stand you in better stead than if you just cracked on without any thought about the privacy risk to it. And also thinking about how you update your records and show your accountability and fulfill your accountability obligations in respect to that data sharing. Ideally, the agreement you should have a written agreement with the person you're showing the data with, so that it sets out, you know, why you're doing it, what data is going to be shared, what is the basis, what's the purpose, limitations on what the recipient can do, and indeed, because you are sharing it with an outside third party, that has to be reflected in your information notice. So one of those requirements under the information notice is to set out to whom might you be disclosing data. And in terms of you know, the recipient, if you are the recipient of personal data, you're under an obligation under the GDPR within 1 month of receipt to tell those people that you have their personal data. You obviously have to update your own records. You have to be aware that if an individual exercises any of their rights, for example, their right to erasure, their right to be so-called right to be forgotten, anyone with whom you share the data needs to be told about that, and they need to be required to carry out those instructions as well. And of course, as a controller of that information, you then become responsible for it, and so the normal obligations under the GDPR will apply. So security, your data subject requests, and consent, and if consent is revoked, all of that stuff has to be dealt with. And I think that is all I have to say on that one. Nick, thanks.
Hi, yeah, sorry about that. I'm talking into a muted microphone for a moment there. Technology undermines us all. Thanks, Piers, for that. Piers is going to be sitting with us through till the end of the presentation and be able to ask questions at the end. So please keep those questions coming in. So following on really from Piers, what the next steps are, Piers gave some great action points of things that you can start thinking about and actually things that you can start doing. One of the areas that Piers highlighted there was training and basically increasing your knowledge as an individual or as the organisation as to what's expected. Is a key part of becoming compliant, which is why you're attending this webinar today, but also training of staff and people within the organisation to help with that journey is also key. So I thought I'd just start off by giving you an idea within an organisation, a school, a company, the various roles that GDPR are going to affect, and how we've, as you'll see as I progress through, we've broken our training down to address these particular areas. So quite key. all the information you'll read on the internet, it talks about getting the trustees, the board, the senior leaders, the key people, the decision makers, the owners in whatever organisation fully up to speed of what GDPR is and the importance of GDPR. Still a lot of uncertainty within many organisations, particularly trustees and boards, as to what it actually is. But some people just see it as a small update to data protection, but it isn't. It's a lot more significant than that. And if you are one of these people on the call today, or you're dealing with the board, it's very important that they're aware of, as Piers mentioned, the financial cost, but it's more the reputational cost of getting it wrong. I don't think anybody wants to be one of the first organisations that are dragged across the front pages of the tabloids for having a data breach. So it's really the reputational cost could be quite significant of getting it wrong. So making sure the board is educated and understand that is quite key. You also need their support and buy-in. That they will be funding this and driving it, so you need them to understand the importance of it. Next person in the chain is we would call a practitioner. So the practitioner is the person who's got the responsibility to ensure the organisation is compliant. So the data protection officer could be the headmaster, could be a head of department. It could be one of somebody here on the call today. So basically the person who has to understand everything about the GDPR and then can put together a plan of what needs to be done and what the organisation needs to do. So they need to know everything there is really about the GDPR. Next on from the practitioner, typically within organisations, they will then hand the job down to somebody who actually has to do it. So we call that the foundation. Within a school, it may be different departments. It may be somebody in charge of HR or a safeguarding officer. It could actually be the same person. It could be one person in the organisation has got responsibility to understand it and deliver it. So really they need to know a lot about the GDPR, but they really need to understand what needs to be done and how to do it, and not necessarily, excuse me, other things that may not be relevant. And then the final piece of the jigsaw is all the staff. So everybody who works within your organisation who is dealing in any way with data that could be classified as personal data, and as Piers pointed out, it's not just children or adults data of the people who are attending your organisation. It's your own staff, your own employees, any personal data. It also includes IP addresses, so it's quite far-reaching. Any staff who has dealing with that information needs to have a basic understanding of the law and what the GDPR is and what the Data Protection Act entails. And ignorance is not defensible in a court of law. The fact that people didn't know is not acceptable. But also, I mean, everybody wants to comply, and having your staff understanding what it is you're trying to do and what their responsibilities are, as well as will help you, excuse me, in driving that compliance and getting everybody to understand what you need them to do. And as Piers says, it also will provide the organisation with an auditable record that you can demonstrate, should you ever be inspected, that you have taken it seriously and you have trained your staff seriously. Excuse me. So what next? Now we've established that that needs to be done. We keep a regular, every time we do one of these webinars, we do a quick Google search and find out, simply type in GDPR and see how many results. And we did it on the 6th of December today, and as you see, nearly 750,000 results of where the word GDPR has appeared within the last 30 days. So it's a huge amount of information out there, and we started doing this back in August, September time. We did something earlier on in the year, and I can tell you in January or February of next year, I don't think we even had some 200. So really, it's something that's getting more and more information out there, which in itself is a challenge. You know, you can attend classroom training sessions. There's big events out there for you to go and attend talks, webinars such as this one, guidance from the ICO website, which I'm sure most of you will visit, and if you haven't, you should. White papers, legal guidance from Clayden Law and organisations and lawyers. There's auditors and management companies and IT companies all there to help really the different elements to provide you with information. And there's a lot. It's a lot out there. You know, where you start, figuring out what's relevant. There's a lot of misinformation, a lot of misunderstanding out there. So can you believe what you're being told? There's a cost implication potentially of engaging with external partners to help you through this process and understanding how much it's going to cost. So clearly there's you've got to spend a lot of time going through, siphoning out and making the decisions. Well, the good news is, from a training point of view, we think we can help you. We've actually created, with Piers' team at Clayden Law, a suite of training that is effectively the equivalent of a 4-day course, which will get, if you took all of the training, get an individual fully up to speed with the GDPR, and with lots of hints and tips. A lot of the information that Piers has just been through is included within the content, all delivered through a secure web-based platform. Up to date is quite keen. There's more legislation going through Parliament. The Data Protection Bill, which our courses have been updated to include the Data Protection Bill, but it doesn't go into law until early next year. I think early May, and there may be some more changes. So we will keep the content up to date and relevant, so that it becomes a resource for you and your organisation to revisit and keep up to speed with. We also are offering on the courses some one-on-one consultation with Piers and his team. So if you do want to speak to somebody having gone through the training, then that's a consultation is available over the phone to help put things into context for your organisation. Just before I go to the presentation and show you some of the e-learning, and then answer some of the questions. The way that we've approached this is that we've created on the left a list of modules. Each of those modules, first one introduction and background, second one definition, principles, the law, and so forth, down to supply chain management. Takes around 20 to 40 minutes, depending on the module, and we've effectively packaged them or bundled them into groups and aimed them at the relevant people within an organisation. So as a school or an organisation within the education sector, you may have a number of people on your board and trustees that you want to take and make aware of GDPR. So we would recommend they take the introduction and background, the steps to compliance, and the sanctions, remedies, and liabilities. So what is it? What do we need to do? And what's the implication if we don't do it? It's the fundamental message. They just need an overview, an introduction, a background, and a bit of information on the definitions and principles and individual rights. And you may want to put a course through maybe an hour and a half long course for your staff, and then the practitioner and foundation have pretty much all of the courses, as you can see. So between an hour and a half for one core or board, or a full 5 hour, which, as I mentioned earlier, is equivalent to 4 days of classroom training for the data protection officer or the lead within your organisation. So I'm not going to go for too long on the demonstration, but I just wanted to quickly show you the e-learning, a quick sample of the course. At the end of the presentation, I'm going to hand over to Kevin, and he's going to just give you a little bit more information about the course and how you can get access to it yourself. So we will be able to give you access to a page similar to this, where you can go and have a look at examples of some of the courses. So we can see here the 4 courses are listed out in front of us. And typically, when I would log in as a learner, I would see the course that's been allocated to me. If I was going to go into, for example, the practitioner course, where all 10 courses are there, if I click the access course button here, if you bear with me, there we go. You can see all the courses that come, all the modules that come with that course are listed out here. And the idea people would process through these and take the course. Each course has its learning objectives and its content, and it has various different links and guides. So I'm going to launch, for example, the Steps to Compliance course, just to give you a quick feel for what it looks like. As I say, I won't dwell for too long on this. I'll just highlight some key screens. Sorry, just turning the volume up there.
The GDPR comes into force on the 25th of May 2018, and there is no end of information out there on what organisations need to do to get themselves ready for GDPR compliance. In part 1, we will focus on the following topics: awareness, accountability, data mapping, grounds for processing, consent, the Data Protection Officer, DPO, privacy by design and default, and insurance. GDPR compliance is going to need an allocation of resources, both in terms of people and money, plus the fact that it needs to be approached on a cross-organisational basis. The obvious starting point is that awareness across your organisation, and most importantly at board level, is a must. Budget needs to be allocated to help. Data controllers and processors are now required to implement appropriate technical and organisational measures to ensure and be able to demonstrate that data processing is. The GDPR provides little guidance as to what measures you need to take to meet your accountability obligation. The guidance simply states that
So I'll pause there. So as you can see, there are a number of slides we're going to go through. We've on slide 15 of 17. I can see I'm going to go through data mapping, grounds for processing, consent. There are videos. There are links to useful information. And there is a quiz at the end. So each of the modules contains a short quiz that people need to take, which asks questions, and then at the end of that module, if they pass the quiz, they can then progress onto the next module. Once the module's been taken, people can go back and revisit it, and as I mentioned earlier, we will update the modules should laws change, and they will be refreshed in May when GDPR actually becomes Data Protection Act in the UK and comes into law. So we will be updating the courses so people can go back and take the courses there. So it really is a kind of a persistent learning space where you can keep up to date and up to speed with the GDPR. So I'm just going to briefly flick back on my presentation, and just really to summarise, nothing new about e-learning really. It's the same old, same old. You know, with respect to GDPR specifically, there are training courses to go out where you can pay to take a 3 or 4 day course, and that sort of cost. And obviously with online training, it's more convenient for you. Based on research, SMEs are typically spending £3,000 or £4,000 on legal fees and fees with consultants, and I'm not sure where we are in NHS and education, but there certainly is a cost involved in getting up to speed and understanding. And the information that we provide in our course has been, as you know, written and in partnership with a lawyer. So we could potentially save a lot of legal costs, especially if we're adding a consultation in at the end of the e-learning course. So hopefully a lot of useful information within the course itself. Obviously saving you time as well. We've put this all together for you. 750,000 hits in the last 30 days. There's a lot out there. So hopefully we can zero in on the relevant, pertinent information and give you everything you need, and you can rely on it being correct. And really finally, just keeping an auditable record of everybody's training, as Piers said, is very important to demonstrate that you're taking compliance seriously. So that's one of the other side benefits of an online training solution. So that brings me to the end of my presentation. We do have some questions. So before we go to those, I'm just going to briefly introduce my colleague Kevin. If I'm going to unmute his microphone. Hi Kevin, are you there?
Yes. Hi Nick.
Hi Kevin.
Thank
you are live.
Brilliant. No, thanks for the intro, Nick. Good afternoon, everyone. My name's Kevin Patrick. I'm the education specialist here at Me Learning. So it's really my pleasure to work with schools and teachers about implementing our training and our e-learning. So I just wanted to take this opportunity to let everyone know that you know, please feel free to get in touch with me using the details on the screen to discuss sort of any of the GDP training requirements, whether it's you know, something immediately or this side of the year or even in the new year. I'd be more than happy to help and give any guidance that I can. And I also wanted to take this opportunity to let you know about our special offer that we're running specifically to schools. We're basically giving away 2 free licenses of our board level training, GDPR training, to every school, which will give access for 3 months. And generally aimed at sort of senior management, so sort of schools would be head teachers or deputy head trustees, but obviously anyone who signs up can take the course. So if you would like to take me up on that offer, please do drop me an email. And as I said, if you've got any questions, I'd be more than happy to help. Anyway, thanks for this opportunity, Nick, and I look forward to speaking with you, some of you, very soon.
That's great. Thanks, Kevin. So I'm just going to bring Piers back online. Unmute Piers. Where is he? And we're going to take some questions. Hi, Piers. Are you there?
Yeah.
Great. Thanks for hanging on there, Piers. Really wait, and we have some good questions. We're a bit short on time, so we'll rattle through a few. So in order that they were asked, it's probably the fairest. Question here: what do you mean just now about how will you update your records in terms of accountability? How will update records in terms of accountability?
Oh, sorry. I'm really just trying to emphasize the fact that if you are sharing data with anyone else, or indeed you are receiving data from anyone else as a data controller, then of course that needs to be that process needs to be included within your records policy. Your records of data processing, I should say. So the requirement under the GDPR is for organisations to keep records of their data processing activities as to who, what, where, how, and why, and that's just one element of that. So the data sharing piece is just a component of that.
Okay, great, thanks. Do independent schools have to, by law, appoint a DPO as well as maintain schools? That's
a really good question. Really good question. So obviously they're not a public body as such. So that requirement does not apply to them. There is still nevertheless a requirement on organisations who monitor individuals or do a large scale data processing, and we're awaiting guidance about whether, to what extent a private school might fall within that category. I would say, even if it doesn't, having a DPO is nevertheless a really good idea for schools, independent or otherwise, from their sort of demonstrability point of view, and it just means that you've got one person who can help with the compliance picture.
Okay, thanks.
In summary. The mandatory obligation probably doesn't exist for independent schools, but it nevertheless is a good idea.
Yeah. So what we're saying is it's not mandatory, but it's a good idea to have
probably,
one.
Probably, depending on what. Yeah.
Okay. Yeah, I've had a couple of questions actually from a couple of people, and we probably need to take this one offline, but just asking for advice about getting to somebody to come in and help with an auditing framework, and actually help them sort of set up an auditing framework for a group of academy schools. So I'll talk about that one offline with you, Piers, and a couple of people asking whether there are any e-tools as well, or any systems to help undertake the mapping. So we'll come back to people who've asked those questions. Another question: how does GDPR affect further and higher education organisations? I guess in the same way as it does all organisations.
Yes. No. It's exactly the same, I'm afraid. Exactly the same. So there's no distinction there. I think that those organisations are certainly going to be public bodies, and so that those same considerations apply. Yeah, I guess you're moving away slightly from the children aspect, because certainly they're not seen as children over the age of 16, but nevertheless, the full weight of the GDPR is relevant.
Yes, there's an interesting question that one of people on the call represents 12 academies. And the question is does each academy, the DPO, or can they as a trust create some sort of...
So a group of organisations that are forwarding within the same umbrella, if you want, can share a DPO, certainly.
Right.
But subject to the fact that the DPO obviously can't be spread so thinly that they're unable to do their job.
Right.
So theoretically, yes. Practically, it would depend.
Okay. Another quick question: how long do we need to keep application forms for people who've applied but not been appointed? Same question about archived files. How long before they need shredding?
So very good question. I've got no sort of right and wrong answer to that. You have to think about the life cycle of that application, whether you might need it. I mean, an application that goes no further, I suppose, you would be looking very much at the shorter end of the spectrum there. There's no reason to keep it any longer than potential, I don't know, months, I'd say, rather than years. Sorry, what was the other element, Nick?
So about archive files, yeah. How long before archive files need to be shredded?
Again, you see, you shouldn't be keeping things for any longer than you need to keep it. So, but if those files may be subject to a regulatory audit or legal action, of course, you should be thinking about keeping them for 6 or 7 years after, from their sort of end of life, as it were, end of life, and then. So each record, I'm afraid, each category of record needs to be looked at on its merits.
Okay, thank you. Yeah, I think the person asked the question popped in saying now staff records that they're talking about. So I guess staff records, I guess people
those are effectively employment records, and so certainly a 6 year cut-off for that it is not unusual. In that arena, yeah.
Okay. Final question then, Piers, and we'll let you go. I think it's a quick one. Really, would like information on how GDPR affects academies. I guess that's the same as further and higher education and schools. It's all effectively the same, is it? I guess.
Yeah.
Same way as the schools. Yeah. No difference.
Yeah. Definitely. Yeah. Afraid so.
So great. Okay, great. Well, that's brought us to the end of the presentation today. I hope you found it helpful and of interest. I've just put up on a splash screen now where you can get further information from us, from our website, from Piers' team at Clayden Law, and from Kevin and from myself. I wish you all a good afternoon. Thank you, Piers, for your time, and everybody have a good afternoon. Thanks very much. Goodbye.
Okay, thank you. Bye-bye.